Welcome, everyone. Thank you for joining us today at our Lunch and Learn webinar on compliance. I'm Stephanie, and I work in compliance and am a special projects manager here at Reference Services. Just a reminder, we are recording the webinar today, and the recording and slides will be sent via email within the next day or two to everyone who signed up to attend. We want to start with our legal disclaimer. Just as you know, we are a consumer reporting agency and we are not attorneys, so any information given in today's webinar is educational in nature and should not be considered legal advice. Joining me today for the presentation is Alicia, RSI's Director of Operations and Compliance, and Heather from our Client Services team. Our agenda today includes coverage on why bother doing background checks, taking a look at negligent hiring and what constitutes a comprehensive background screening. And then moving into some other compliance topics, we have FCRA end user obligations and taking a look specifically at permissible purpose and end user certifications, adverse action, and authorization forms. We're going to touch on UDAAP, CRA reporting, take a look at Social Security trace and the credit header data contained in that report, and the adverse action process, along with some state challenges and guidance on sharing reports with a third party. Once we cover those topics, we will have time at the end to address any questions you may have. And now I'm going to turn it over to Alicia to get started.
Hi, everyone. So we wanted to start out with background checks and why bother doing background checks. So some of the statistics that we found are a total of 786,838 people are listed on the state sex offender registries. This is as of February of 2023, which is a 3% increase from 22. According to Checkster, 78% of candidates misrepresent themselves on a resume. This exhibits a lack of ethics on their part. Indeed, estimates 40% of people flat out lie on a resume, and we do see that here from time to time in our verifications department, especially. We see people that aren't truthful about college degrees, maybe dates of employments or positions that they held. And then Quest Diagnostics states that 4.6% of drug tests came back positive in 2022. This is an increase of 31.4% from an all-time low of 3.5% in 2010 to 2012. So our industry began largely due to claims of negligent hiring. This also is retaining an individual who subsequently engages in violence. Negligent hiring is defined as the failure of the employer to investigate a job applicant's work experience, character, criminal history, and other relevant data prior to the hiring of an employee. So employers are responsible for what they do know, and then this is super important, and what they should have known about their employees. Employers lose approximately 79% of negligent hiring cases with an average claim of over 1 million, and it's climbing. So we just found a case from last year where a jury awarded one of the largest verdicts in American history against a cable operator for a murder that one of their technicians did. This negligent hiring verdict was for more than $7 billion. So what happened was the technician had gone to this elderly individual's home, fixed something for them, found that they were living alone, and then went back days later and murdered her.
Thanks,
I am going to
Alicia.
turn this. Thanks, Heather.
So as Alicia mentioned, negligent hiring cases can really climb up there in the amount. So you want to make sure that not only are you doing a background check, because there is an assumption that every company does some type of background check, but it's how comprehensive that background check is. So not all background checks are the same, and you really want to partner with a third party CPA that does have very compliant background checks with lots of data sources. So, of course, some of you may know that our comprehensive criminal package, this is, our name. This is not an industry standard name. We call this our comprehensive package, which includes the nationwide criminal search with alias, which searches over 2,200 databases. And it includes things like the sex offender registries in all 50 states, Department of Corrections in all 50 states, again, over 2,200 sources. This package also includes a Patriot search. You may see this on your reports as a nationwide PS. So this includes a lot of the watch lists and exclusions lists as well. And then, of course, we were all familiar with the Social Security trace. I'm not sure if a lot of people know that really the primary purpose of our social trace is not for your hiring purposes. It's so we can find the address history and alias names. So we'll populate those jurisdictions, the counties where they've lived in the last 7 years, as well as search any of those alias names at no charge on the nationwide search. And then, of course, we always recommend including county criminal searches in a 7-year address history. Some clients, companies, industries do have a statewide requirement. It's not necessarily something that's included in our comprehensive package, but it's available if you ever have that kind of requirement. And then finally, the national federal criminal is the only way to uncover federal charges. So that's at the U.S. District Court level and would not be found on your nationwide or county criminal searches. In most cases, you need to do that national federal search to find those, big federal charges, child pornography, drugs across state lines, fraud, identity theft, those kinds of things. So if you are not currently incorporating a national federal criminal search in your background checks, you may want to consider adding that.
All right, thanks, Heather. Now we're going to cover end user obligations under the FCRA. So all RSI clients are considered end users of consumer reports. And when you sign on and are credentialed as a client, you agree to the federal document called Notice to Users of Consumer Reports, Obligations of Users under the FCRA. And we're going to touch on some of the topics that are in that document. All end users must have a permissible purpose, provide certifications, and follow specific adverse action procedures when you're obtaining a background check. Additional requirements, such as specific authorization and disclosure documents, are required when obtaining reports for employment purposes or when obtaining investigative consumer reports. And an investigative consumer report is anything regarding character, general reputation, personal characteristics, and/or mode of living, and that is obtained through personal interviews by a CRA. Most commonly, those are referred to as reference checks. But depending on your employment verification, if you add additional questions, that could possibly also be considered an investigative consumer report. So I mentioned all end users are required to have a permissible purpose. And that is, one of the main things. We have to make sure our clients have a legitimate reason for requesting a background check on someone. And part of that process of ensuring that is getting an end user certification. So when you may notice when you order a background check, we do request a certification similar to the one you see on screen right now. I just wanted to point out that last bullet point on the certification does verify that you have permissible purpose for obtaining consumer reports in accordance with the FCRA, and you certify this purpose to be in connection with an employment or volunteer application submitted by the consumer. We have a different certification for, for example, for the tenant screening industry. Obviously, they're not running reports for employment purposes, so it says in connection with a tenant application. So we do have there are different permissible purposes, and we do obtain like what type of permissible purpose you have as an end user. All right, and now I'm going to turn it back over to Alicia to cover adverse action.
Thanks, Stephanie. Sorry, my mic wasn't on. Yeah, so we wanted to cover adverse action and the process that we go through, or that you all go through. So adverse action is defined by the FCRA as denial of employment or any other decision for employment purposes that adversely affects any current or prospective employee. It's also defined as an action taken or determination that is made in connection with an application that was made by or a transaction that was initiated by any consumer and adverse to the interests of the consumer. So it doesn't mean just hiring a new employee. It's also if the adverse effects are termination, maybe a promotion that they were denied because of their background check. It includes anything that could be viewed negatively by the employee or cast them in a negative light. It also includes adverse outcomes of tenant screening. So denying of an apartment or higher security deposits, maybe. And then the process that is required, the multi-step process is if you make a decision based on the background check at all, your first step would be to send the pre-adverse action notice. And this notice includes a copy of the report and a summary of the consumer's rights under the FCRA. So that is built into our system. All of that is sent to the applicant with that pre-adverse action notice. And then begins the second step, which is the waiting period. It's required by the FCRA to wait a minimum of 5 business days. Some of our clients choose to wait maybe 7 business days to give that, give the applicant a couple more days to maybe dispute the report. And if the applicant does call us to dispute the report, we would let you know right away. And then that process should come to a halt. So you wouldn't want to send the post adverse action notice until we let you know that the dispute is complete. And we do those, we do work disputes as quickly as possible. So we make sure we reach out to you, we reach out to the county, whoever has given us the information, just to verify that it is accurate. So the third step of the process is the post adverse action notice. So if you haven't heard from us that the consumer has disputed the report, or if they did and you've heard from us that that the dispute is complete, then you can send the post adverse action notice. And that again has a copy of the report and a copy of summary of rights included with it. And we just wanted to note that the RSI's platforms are customized for those adverse action letters and the supporting documents. So it's all sent together with just a push of the button. Now I'll turn it back over to Heather.
Thanks, Alicia. So we'll talk a little bit about the authorization forms. So there are several forms that are required for any background check. So the acknowledgement and authorization form, which is the authorization for both you as the company and reference services to perform the background check. As well, the acknowledgement part is them acknowledging that they did receive the separate disclosures, which we're going to talk about. And that acknowledgement and authorization form also includes their, personal information, name, social, etc. The disclosure regarding a background investigation is simply disclosing what may be included in this report, criminal records, employment verifications, driving history, etc. It doesn't say that it necessarily is including everything. It is just that it may include these items. Those first two forms, the acknowledgement and authorization form, as well as the disclosure form, will be signed and completed and returned to you. The summary of rights you should always be including in the copies you're giving to your candidates. That is simply a copy for them. It just lets them know what their rights are under the FCRA when it pertains to, disputes, getting copies, etc. Now, there was a new summary of rights update at the beginning of 2023. And those changes weren't necessarily legal changes, more on formatting and new contact information. However, you should be complying with the new form by April 20th of 2024. That document can be found on both of our platforms. If you don't have it, certainly reach out to us if you cannot locate it. But you should be making sure that you are using the new summary of rights by April 20th this year. Now, some states do have state-specific notices and disclosures as well. So, if you're running a background check in California, or there's a notice to provide in San Francisco, you should be aware if there are any state-specific notifications or notices or disclosures that you need to provide to your candidates. But just make sure that all of the forms are on separate pages. They cannot be combined into one page, one document, and always keep them short and succinct. So we do provide those sample forms for our clients that we have reviewed very regularly by our FCRA attorneys to make sure they're current and up to date. We provide those templates that you simply, just a small bit of customization. But in most cases, if you're using our applicant invitation process in either the platforms, Quick App or App Screen, those forms are built in. So if you're using those applicant entry systems, then you don't need to obtain these forms hard copy. They will be signed electronically in our system. And please note that if you are running any background checks on a minor, our systems will not request a second signature from the parent or guardian. We do have the minor authorization and disclosure form templates we can provide to you as well. It is the same document, but simply includes a separate line for the parent or guardian signature. And that is your responsibility to make sure before you screen a minor, you do have that parent or guardian signature. We're going to talk a little bit about the Social Security trace now. As I mentioned before, the social trace data that you receive on a background check is not to be used for hiring decisions. That's very important. It is not considered an FCRA product, so you cannot, if you see an alert on your social with a, no address history, a non-name match, date of birth mismatch, those alerts are designed for you to reach out to the candidate, reach out to us. We can take a look at the report, make sure all of the personal information was entered correctly. So maybe that date of birth might have been entered incorrectly or the social security number. But just keep in mind that primary purpose for that social trace is for us performing the background check. So those alias names and county jurisdictions from their address history. And you see those notes on some of the reports that state you cannot use that for employment purposes. There is some discussion now on possibly changing how that credit header data is interpreted, which is one of the data sources in our social trace. So it's collated from a variety of searches: credit header data, warranty registration information, change of address forms, social media, etc. So it's not always 100% accurate, and it can contain occasional incorrect information. That is not anything to be concerned with. It's just designed to have you confirm that the data was entered correctly again. So there's nothing really set in stone now about how they're changing whether credit header is interpreted on a background check. So for now, just know that you should not be using that for your hiring decisions. And I'm going to turn it back over to Stephanie.
Great. Thank you, Heather. I'm briefly going to touch on UDAAP today. The UDAAP stands for Unfair, Deceptive, or Abusive Acts or Practices, and it is defined under the Dodd-Frank Act, and that prohibits UDAAPs against consumers or applicants. An example of a UDAAP in background screening might be not providing required FCRA disclosures prior to running a background check, or failing to maintain adequate data security around, the background screening information, their social security number, date of birth, and things like that. Those types of things can be considered a violation under the Dodd-Frank Act. Just want to give a couple quick additional points. It doesn't matter if the act is intentional or unintentional. Companies can still be held responsible for an act that is, considered unfair, deceptive, or abusive against a consumer. A company can also be fully compliant with the FCRA and other consumer protection laws, but still violate UDAAP laws. So it's just another layer of things that govern background screening. There is an obligation to protect consumers and keep their best interests in mind. And that is, something that RSI takes to heart. We do, consider the consumers or applicants just like a client, and we treat them as such. And we are there to help them if they have questions or if they believe their background check is incorrect. It's our job to make sure that we're reporting the correct information to help keep their best interests in mind. So just a quick overview on UDAAP. And now I think Alicia is going to take a look at reporting.
Yes, thanks, Stephanie. Yeah, so we wanted to kind of go over what we look at in the criminal portion of the company, standard scope, state law, federal law, that type of thing. So the federal rule, so the basic rule that we look at is convictions are reportable forever. Non-convictions, pending and deferred charges are reportable for 7 years from the charge or file date. And we never report sealed or expunged records. Now, there's employer laws, and then there are CRA reporting laws. Some of you, depending on what type of industry you're in, maybe it's industry and state, that might govern what you can and can't see on a background check. We don't necessarily know those. So if you reach out to us, we can add special instructions to your account to customize your report. Maybe we can hide some things that you are not allowed to base an employment decision on, or maybe you want to see misdemeanors over 10 years, so just let us know and we can customize that for you. Just to mention what we mean by CRA state reporting laws are, just for example, some states may limit to convictions are reportable within 7 years and nothing over 7 years. Some states have requirements based on salary, so maybe we can't report even convictions over 7 years if they don't make a minimum of $20,000 or $25,000 a year. So there's a lot that we take into consideration when we are processing criminal records. And then some of the state challenges that we've been watching lately, there's been a lot going on in these states. So Kansas, you probably all have heard that they had a cyber attack on October 12th. It affected the entire judicial system. So it wasn't just CRAs that couldn't see records in Kansas. It's absolutely everyone, court workers, judges, lawyers, nobody could see these cases. So in that instance, we went ahead and asked our clients and started swapping Kansas counties out for the statewide. Currently, they have brought the system back up as of early January. However, the records from that cyber attack date to current are not showing. So we're still recommending that those counties be swapped out for a statewide until further notice, until it's fully back up and running. And then Michigan has been quite a mess. It's, you name it, and they are undergoing it. So it's removal of PII, which is personally identifiable information, basically meaning date of birth. And when we're going through criminal records, we're wanting to have a minimum of 3 identifiers. So most of the time we can get name and date of birth from a record, and then we're trying to pull in address history, and anything else we can. Well, with the date of birth being removed from a lot of records nationwide, it's making our jobs a little bit harder, and it's making turnaround time, just a little bit longer also. So Michigan has gone under the removal of PII, clean slate law, where they're removing some records that fall within that criteria. And they also, along with South Carolina, we have found that they have added anti-scraping technology to their systems. And what that means is, so our nationwide report is an instant criminal report, where it actually goes and scrapes data nationwide for name and date of birth. But with Michigan and South Carolina adding that software to the system, we're not able to we feel it's inaccurate. We might not get records. It's kind of spotty. So for that instance, we are making recommendations to clients based in those states, maybe adding a statewide. South Carolina doesn't have a good statewide, but for Michigan, we're adding a statewide. South Carolina, we are suggesting alias searches be added to counties. And then California is kind of like Michigan. They've removed personal identifiable information from the entire state. So they are basically fully clerk assisted state, where it's not electronic at all anymore. So the turnaround times in California have suffered a little bit, but they are getting a lot better. And they've also undergone the clean slate law. So just a few mentions there. But we do monitor orders daily to identify problems in jurisdictions. So we will notify you if you have any orders that are affecting these are affecting. And then we also add ETAs to orders. Generally, that starts after the 72-hour mark, because most orders are completed within that first 72 hours. But if the turnaround time needs to be added to the other reports, then we usually add those, so you can log into the system possibly and see what the estimated time will be for completion. And then we wanted to touch on sharing reports with third parties. So PEOs, or professional employment organizations, staffing agencies. If you are sharing reports, the courts may consider you a CRA, which requires you to follow FCRA laws, which includes dispute, reconciliation, etc. So you don't want to be doing that. The best process is to certify that the applicant or employee passes the HR policy of your third person, but not to share the report itself with the third party. Sorry, third party, not third person. The authorization forms say the CRA and end user are the only parties authorized to view the report. So you being the end user and us being the CRA should be the only two parties seeing those reports. The third party should not. It's not included in that authorization form. So if necessary for the third party to view, there are some options. You can have a separate end user agreement with the CRA for the third party, or add the third party to the authorization form, so that when the applicant is signing that authorization form, they're authorizing you to share that with the third party. Or the best way, or the easiest way, is for the applicant to just share their report with the third party. That's always something that they can do. And now I'll turn it back over to Stephanie for the key takeaways.
All right. So just a few things as a reminder before we wrap up. Make sure the RSI team is aware of any special instructions you have for reporting on your criminal reports. Don't share reports with third parties. If you are working with third parties, reach out to us and we're happy to guide you through that process. Make sure your team is aware of adverse action requirements and review your authorization forms and make sure you're using the updated version of the summary of rights. I did want to just throw out a quick announcement. We do have a link where you can sign up to receive notifications of future webinars. Obviously, all of you here probably received that email, but if you'd like to sign up anyone else on your team, they can do that using the link, and I'm going to post that in the chat here shortly. Also, you can feel free to ask your questions in the Q&A section or possibly in the chat. I think I see maybe a notification there. So I'm going to post the link to the sign up. We're going to answer some questions now. And I'm going to turn it over to Heather to see what kind of questions we have coming in.
Thank you, Stephanie. First question that came in, if we don't run a credit report and are only doing a criminal background check, do we still need to provide the summary of rights? And that is a resounding yes. The summary of rights is not just about credit report. I think the headline is a little confusing because it says summary of your rights under the Fair Credit Reporting Act, but that is the FCRA, which governs all consumer reports. That summary of rights tells them that they have a right to a copy. They can dispute information, so there are a lot of other there's a lot of other information in there that is applicable to any consumer report, whether you're running a credit report or not. We also have a question, if an employee would like to have a copy of their report, can we give them a copy? And absolutely, you are required to. So the consumer report, if any candidate, employee, applicant asks for a copy, you cannot tell them no. That is their information and they have a right to a copy. And that could be another workaround for the sharing of a report is the candidate can share that with whomever they wish. So, since it's their background check and their information, they are welcome to share that with, as you mentioned, Doug, a volunteer organization. Let me check the Q&A again. I do not see any additional questions. You're welcome, Doug. I'll give you just a second for anybody to type in any additional questions. I do see we've got to past the 11:30 mark, so don't want to hold you up much longer.
Heather, I see a question coming in the chat.
There's another one. Hello, Sandy. Can you explain how your search process is different in Michigan and South Carolina due to the anti-scraping? I'll let you address that, Alicia.
Okay. So, yeah, it's in Michigan, they have a good statewide. Well, I wouldn't say good. We don't report straight from the statewide, but at least we can use that as another pointer, which is what we use the nationwide for. The nationwide points out cases that maybe aren't in that person's, say the person didn't live in a county, the nationwide will point us to that information, and then we can order a county search for that. So we can use the Michigan statewide as a secondary pointer, basically, which will notify us to, hey, we need to add another Michigan county to the search. South Carolina doesn't really have a statewide like that. So in South Carolina, we are basically, a lot of the cases are still going to show on the nationwide, but as a secondary, I guess, cushion, we are asking, especially our clients that are based in South Carolina, to add alias to the county searches, alias names. So that way, if they do have a count or a criminal charge in that county, the Nationwide may have pointed us that, hey, this charge was actually when they had a different last name, and then we would manually order that county in that alias name. So that's why we're adding the aliases to those counties so that it will catch anything in that person or for that person. I know I kind of went deep with that and it's hard to explain, but I hope that helps a little bit. But yeah, just give
Yes.
us a call if anybody has any questions.
Yeah, Sandy said that explained it. All right, I don't see any other in the chat or the Q&A now, so I guess that will wrap things up.
All right, I just want to send another quick reminder. We are going to have the recording and slides sent out via email within the next few days. And just want to thank everyone again for attending the webinar. Have a great day.